Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
Welcome to Ganga Education, standard form contracts under the Indian Contract Act 1872. Hey everyone, I'm your host, and today we're jumping right into a premium legal masterclass made specifically for your judiciary and NET/SET exams. आज का topic contract law का absolutely crucial और सबसे practical हिस्सा है. So let's dive right in and see how the modern world actually enters into agreements on a daily basis. Sach batana, have you ever, even once, actually read those 50 pages of terms and conditions before clicking I agree on an app? Nope, right? We all just blindly accept them. And honestly, this right here, it's the ultimate David versus Goliath struggle. एक तरफ है एक आम consumer, you and me, the little guys, और दूसरी तरफ a giant corporation with massive bargaining power. तो सोचिए, is the traditional meeting of minds really happening here? That is the core conflict of standard form contracts. Okay, so our roadmap for this explainer is super clear. We're going to cover the meaning in statutes, what makes these contracts valid, the judicial protection doctrines you need to know, landmark cases, modern digital trends, and we'll wrap it all up with a quick, rapid-fire revision. Let's kick things off with the exact meaning and the governing statutes. You see, contract law has shifted dramatically. We moved from the classical 19th century will theory, where two equals sat down and bargained over every single clause, to today's standardized mass commerce. और यहाँ सबसे interesting term जो सामने आता है वो है contract of adhesion. Why adhesion? Because a weaker party has literally zero negotiation power. आपके पास सिर्फ दो options है, take it or leave it. You just have to adhere to it. Oh, और exam में ना एक और keyword बार-बार आता है, lien in contract. Think of it like the lion's share. सारे benefits उस party के पास है, जिसने draft किया और consumer के पास कुछ नहीं. Those boring boilerplate terms? Yeah, they leave you completely powerless. To put this into perspective for your mains exams, think of it as a contrast. एक तरफ you have negotiated contracts. यहाँ equal power है, flexibility है, और सबसे important, subjective consensus addendum, यानी actual meeting of minds होता है. पर दूसरी तरफ standard form contracts. यहाँ power totally unequal है, rules rigid हैं, और speed को number one priority दी जाती है. Standard forms में हम subjective mind meeting नहीं देखते, बल्कि एक objective manifestation देखते हैं. आपने क्लिक किया या साइन किया, बस बात खत्म. It's a real game changer in how contracts operate. So you might be wondering, what's the legal backing for this in India? Well, currently, India में इन contracts के लिए कोई specific, separate statute नहीं है. The courts heavily rely करती हैं general principles पर under the Indian Contract Act of 1872. Specifically, Section 10K essential ingredients, like is there free consent, is the consideration lawful? And then, the absolute biggest weapon the courts have is Section 23, public policy. अगर कोई contract public policy के against जाता है या blatantly unconscionable है, the court उसको सीधा strike down कर देगी. Right, moving on, let's talk about the exact essential ingredients that make these contracts valid. अगर एक standard form contract को truly valid होना है और judicial scrutiny survive करनी है, तो उसे इन 4 sequential steps को pass करना होगा. ध्यान से सुनिए. First, contemporaneous notice. इसका मतलब है टर्म्स का नोटिस कॉन्ट्रैक्ट बनने के टाइम पर या उससे पहले मिलना चाहिए. Definitely not after. Second, contractual nature of the document. भाई सिर्फ एक लॉन्ड्री रिसीट या पार्किंग टिकट अपने आप में कॉन्ट्रैक्ट नहीं बन जाता. The document must be something where a reasonable person expects contractual terms. Third, absolutely no fraud or misrepresentation in hiding those tricky clauses. And fourth, exactly what we just talked about. Section 23, Public Policy Compliance. Now, what happens when things go wrong? Let's look at the judicial shields courts use to rescue the weaker party. जब giant corporations unfair terms impose करते हैं, तो judiciary कैसे protect करती है हमें? There's this incredibly famous, almost legendary quote by Lord Denning regarding the doctrine of reasonable notice. He essentially said, the more unreasonable a clause is, the greater the notice which must be given of it. Some clauses would literally need to be printed in red ink with a red hand pointing to it. मतलब अगर आप कोई अजीब या harsh condition डाल रहे हो, तो आपको ऑफरी का attention explicitly उस पर draw करना ही होगा. Just picture that red ink rule in your mind. It's a brilliant memory trick for your exams. Okay, here's a Latin maxim you absolutely need to memorize. Contra pro forentum. ये standard form contract interpretation का golden rule है. Simply put, अगर contract के किसी भी clause में कोई ambiguity या slight confusion है, the court हमेशा उस party के against decision लेगी जिसने contract draft किया था. Think about it. The drafter had the chance to write clear terms. If they chose to be vague, they have to bear the risk. You'll see this doctrine used all the time, especially in insurance contracts. Another massive layer of protection is the theory of fundamental breach. Listen to this carefully. कोई भी exclusion clause एक पार्टी को उसके core obligation से exempt नहीं कर सकता. Imagine you give your most expensive suit to a dry cleaner. अगर dry cleaner उस suit को अपनी personal party में पहनकर completely ruin कर दे, तो वो receipt पर लिखे छोटे से no liability clause का बहाना नहीं बना सकता. No way, because that breaches the very root, the core essence of the contract. All right, time for the heavy hitters. Let's dive into the landmark cases you need to know.
Judiciary, AIBE, or NET aspirants, get your notepads out. These judgments and their legal ratios must be at your fingertips. Let's do a rapid-fire review of this high-yield table. First, Henderson v. Stevenson from 1875. यहाँ ship ticket के French पर कोई terms नहीं थे, और ना ही see back लिखा था. The result? Notice completely failed, so the terms weren't binding. Fast forward to Thornton v. Shoelane parking in 1971. यहाँ ticket एक automated machine ने issue की. The court basically said, hey, introducing terms after the machine gives the ticket is just too late. Timing is absolutely crucial. And then we have Lily White v. Manu Swamy, a dry cleaner trying to limit liability to just 15% of the cloth's value. The court ruled that's unreasonable and you cannot escape the minimum duty of care under Section 151 of the Indian Contract Act.
And when it comes to the definitive Indian context, look no further than the Brojo-Noth case of 1986. The Supreme Court laid down a massive principle here, holding that clauses which literally shock the conscience are void under Section 23. An employer just cannot do an arbitrary termination without reason. The court beautifully connected this to Article 14, right to equality, and the right to livelihood, specifically to protect the weaker party from unconscionable, dotted line contracts drafted by the state. It was a real game changer. So how does all this translate to the modern world? Let's look at digital and global trends. We have to ask, how do these old common law doctrines apply in today's fast-paced tech world where agreements are purely digital? Well, first you have shrink-wrap contracts, where the terms are physically tucked inside the box. Then there are click-wrap agreements. That's when you manually hit that I agree button. But the trickiest ones? Browse-wrap agreements. This is where a website claims you're bound by their rules literally just by browsing the site. Unsurprisingly, both Indian and global courts are highly skeptical of browse-wrap because the principle of reasonable notice totally fails here. And this is becoming absolutely critical as AI and algorithmic contracts take over our daily lives. Globally, things are evolving fast. The UK has the Unfair Contract Terms Act of 1977. Israel actually went ahead and created a dedicated standard form contract court just to strike down unfair clauses. But in India, we're still mostly relying on judicial activism. That's why, from an exam perspective, you must remember this keyword, the 19th Law Commission Report of India. This report strongly urged the creation of a dedicated SFC Act to tackle both procedural and substantive unfairness. Hit the nail on the head, right? Okay, we've covered a lot of ground. Let's lock this into your memory with a quick revision. Let's quickly trace the evolution of notice jurisprudence. It all started in 1875 with the Henderson case, which established that a notice must be prominent. Then 1971 brought us the Thornton case, highlighting the strict timing of notice, especially for automated systems. And finally, 1986. The Brojo-Noth case took it way beyond basic notice, delivering direct constitutional protection against the state under Article 14 and Section 23. And speaking of Section 23, if you only remember one statutory provision for standard form contracts in your exam, make it Section 23 of the Indian Contract Act. Public policy is the ultimate heavy-duty weapon Indian courts use to strike down unfair, one-sided, and unconscionable agreements. Seriously, print the number 23 in your mind right now. To summarize, here is your ultimate UGC-NET and Judiciary cheat sheet. Validity comes from Section 10. Unfair clauses get struck down by Section 23. The minimum duty of care for bailment is Section 151. The legal maxims you absolutely must write down are contra pro forentum and fundamental breach. And the landmark case tying all this to Article 14 equality, Brojo-Noth. Make sure you have all these exact keywords noted down. I want to leave you with a final provocative thought. As algorithmic, AI-generated smart contracts become the absolute norm in our lives, क्या इससे आम इंसान के लिए contracts finally fair बनेंगे? Or will it just lead to faster, more automated exploitation? Let me know what you think in the comments. For more such law lectures, subscribe to Ganga Education. Keep studying, and I'll see you in the next explainer.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.